Court. I'm here for the applicant, together with other friends, Mr. Perry and Mr. Perry Edwards, and Mandy Makai.
Thank you, Mr. Sulber.
Very pleased the court, I appear together with my learned colleagues Maneki, Kluti and Salugazana for the respondent.
Thank you, Mr. Morale. Mr. Sulber.
Lord, my ladies, you've had the opportunity, we're grateful that you've taken the time to read our argument for the parties in the pages. What I propose to do is to highlight the areas that we wish to focus on, and obviously further detail is included in our written argument. I may start just to sketch the outline because there appears to be certainly a miscommunication between us and the respondents as to what we're dealing with. And the respondent questions whether we're approaching this as a constitutional matter, whether it's a paja, the administrative action that we are doing. Well, we say with respect, it's quite clear what this is. It's a legal issue about firstly proper interpretation of the Disaster Management Act and whether or not, for the purposes of Section 27 properly interpreted, the regulations that we're dealing with and the prohibition that we're concerned with falls within the scope of the Act or whether it's ultra vires. That will entail, firstly, what the ambit is of the regulations that may be made, and the interpretation of the scope of regulations, what purpose, and then we will also address the question of rationality. And it appears to be common cause that whatever one is approached in the matter, the regulations promulgated under Section 27 are required to be rational and rationally connected, certainly, the purpose that the Act has in mind. And we will then address the question, to the extent necessary, of the appropriate remedy. So to make it absolutely plain, we're not mounting a constitutional challenge on either the Act or on the conduct. What we are challenging is whether this is in accordance with the Act and whether it's rational for the purposes of the Act. That doesn't mean, if you're not challenging the constitutionality, it doesn't mean that you ignore the Constitution, because as we familiar, even in private law and contracts, you always have regard to the values that are enshrined in the Constitution in interpretation. And when it comes to interpretation here, one cannot put in blinkers, ignore the reality, and ignore the fact that the fundamental rights that the Constitution does recognize that are at play here. But it is not a constitutional challenge. Also, by way of preliminary observation, the court will have seen that there was some debate in the papers as to whether we are only dealing with Regulation 27 or whether it's been extended to Regulation 45. There are three categories we're dealing with. Our starting point will be to show that even under the original lockdown regulations, where there was no express prohibition against the sale of cigarettes and tobacco products, even there we start and we say, reading those regulations properly, there was no prohibition against the sale of cigarettes and tobacco. That's our starting point. Regulation 27 was then no doubt introduced because there was a debate, and a very much publicised one, between certain ministers on the one hand and the Western Cape particularly, including FETA, and as it's set out in the papers, FETA also raised the proper interpretation. There was a debate about whether or not the original regulations, initial regulations, actually prohibited the sale of cigarettes and tobacco products. And there was a view, and we will submit that in fact it's the correct view, that even in those initial stages where the framework or structure of the regulations was to exclude everything that wasn't specifically included in the annexures, that even there, if we look at the schedule of what was permissible under necessary products and services, essential goods and products and services. Even at that point, we submit it was not unlawful to sell cigarettes and tobacco products. And we'll be addressing the court on that.
Mr. Suber, just before you proceed, and I'm happy you clarified the issue around the constitutional issue. Do I understand you to be saying there is no constitutional challenge to the regulations?
Yes, so it's not challenged on the basis of an unconstitutional basis.
Yes.
Yes. It's legality.
It's legality. Well,
Correct.
that's the other issue. Now, when you say legality, I take it it's settled then that we're dealing with what the respondent says is executive action. Legality targeted at executive action.
So it's really to do with executive action in promulgating regulations.
Yes. Okay. Thank you very much.
So the first, before we even get there, because that's perhaps the second stage. The first stage is, was there ever, under initial regulations, was there a prohibition? And as we'll submit with respect, we submit not. And because of the debate that then raged as to whether or not the initial regulations did prohibit,
Yes.
there was then an express inclusion in the April regulations of Regulation 27. That was then perpetuated in Regulation 45.
Yes.
Now, the argument that was initially attempted by the respondents was that once we moved from level 4 to level 3, and there were now the further regulations with Regulation 45, at that point now put forward an exhaustive analysis and explanation for what justified not only Regulation 27 but also 45. Thank you. Before one gets to even assessing the rationality, and the matter is crystallized, if I may just say something briefly about the approach to being a motion matter. We're alive to the usual tests in classical evidence and the well-known principles, and we're also alive to the fact that the court will not decide, not likely, with final relief on a contested or controversial issue. But what we do submit with respect is what we read in the reasons for decision and the answering affidavit is sufficient to demonstrate that there was non-compliance with Section 27 and indeed irrationality. We submit that the respondent's own version is demonstrative of it, and this is a matter where the court can, and we submit should, find on paper, on the well-known tests of classical evidence, that in fact, taking the respondent's own version, it doesn't justify the prohibition. And we've termed it a draconian prohibition. A ban of this nature is probably the most dramatic of any measure that can be taken. It's difficult to think of anything more dramatic and draconian than a total ban or prohibition, shutting down an entire industry, as we've highlighted, and causing what we submit enormous harm. And what characterizes the answering affidavit is that all the focus from the second respondent has been on a particular issue only. Although lip service is given to having apparently had regard to the other factors, we submit there's no fact set out in these affidavits, the answering affidavits, that show that proper consideration was indeed given. When we read the answering affidavit, it's particularly concerning that there's not a single explanation given, no facts, no figures. One would have expected some proper thought being given to matters of this magnitude. Let's take, for example, the thought given to the shutdown of an industry. The industry is an enormous chain. It starts off at its origin probably with farmers, or perhaps even before that, those who supply the farmers, the employees at that level, the operations of the farmers, the supply chain between the farmers and manufacturers. There's logistics involved in that. There's the producers, there's the distribution, there's retailers, there's the informal traders, and then there's the consumer. And then there's the addict, the tobacco addict. And all of these factors, with respect, are of enormous concern. And when we read the answering affidavit, we find little, if anything, given by way of proper thought to all of these considerations. We have a sweeping statement, generally, and repeated in each context. A thought was given to it, but that is now outweighed by the risk of an increased strain on health services. And my lord and my ladies, there is only one answer given in this application by the second respondent to justify the prohibition. There's only one single answer. The rest is all peripheral and concerned with that. But there's only one rationale given, and if that fails, as we submit, it has to on our own version. With respect, there's no justification left.
Can I just interrupt you there? If one looks at the provisions and the purpose of the Disaster Management Act, and read that in conjunction with the point that you highlight in your papers, what should have been taken into consideration. Can you go as far as to say, in light of the disaster management, that certain factors should weigh heavier?
More heavily than others? We submit not. They must all be taken into account, and there must be a balancing act. But, my lady, with respect, in answering that question, when you balance it and ultimately it is a value judgment. It's got to be a rational one. But when you do that, you've got to take into account, if you're weighing up in the scales, the pros for a ban or prohibition. If there is a risk, you've got to look at what is the severity or degree of that risk. So it's not a fact in itself that you pluck out in abstract and say, I must put in the one side of the scales the risk of an increased strain on the health service. You've got to assess as well, how great is that risk? What increased risk? What severity? And that's where, with respect, it is lamentably poor in its reasoning. It is unscientific, but in fact it's quite clear that this was a very ill-considered exercise in regard to an enormously important issue. And what it's obviously, and it's quite clear what the agenda is, she says it. The second response says, my agenda is to get people to quit smoking. Now, if that is the purpose, and if that's not achievable realistically in the real world, well then there's nothing left. Because if she can't achieve people quitting smoking, then there is no basis to have this prohibition. And we will demonstrate on our own version she cannot answer the question of, is this going to be successful? There is some reliance placed, in fact solely, on a so-called study, which I'll address the court on, by the Human Resource Council, HRC, and that is this, it's a very embryonic, with respect superficial, not even a scientifically motivated report, and that is the sole basis upon which she concludes, and apparently on the basis of some representations by who knows who, when representations were made, that's the basis she concludes that there's an increased risk to the health services. Now, we're not saying, and the applicant has made it clear, that smoking is not harmful. That's not the debate. The debate is a rational connection between the Disaster Management Act and this prohibition. Nobody's saying that eating sugar, consuming sugar, fizzy drinks, salt, red meat, whatever one wants, that's topical, that isn't hazardous to health. The greatest risks on the health system are obesity, the allied diseases, diabetes, cardiac, cancer. And nobody suggests that tobacco isn't harmful. But what we do know is there's legislation in South Africa that deals with the regulation of tobacco products. We will submit, as we have in our heads, that if anything in relation to tobacco and cigarettes is going to cause harm, is going to increase the burden on the health system, it's going to be what is caused by this ban, and that is people being driven to illicit products. It's now an unregulated world. It has no controls, and if I can just very briefly take the court to the tobacco legislation, it's the Tobacco Control Act, which we've referred to, and just to identify that this is legislation that is very careful about regulating the use, including sale, marketing, advertising of tobacco products, with the interests of health. The legislature has got legislation in place to regulate as far as possible through education and other measures, and to control smoking of tobacco products. That's in Section 2 of that Act. Advertising Section 3. But what I do want to focus on particularly Section 6 of that Act. Section 6 is what provides for regulations. And Section 6 provides, and when I get to interpreting Section 27 of the DMA, I'll ask the court to bear in mind what this legislation actually provides. Section 6 provides for regulations and reads, the Minister may make regulations regarding, and there's a whole host of issues here which may be regulated, but the one I want to focus on is sub D of Section 6. So it's 6(1)(d) of the Tobacco Control Act. And very importantly, what the regulations must address is the standards that a tobacco product must comply with, including, 1, the amounts of substances that may be contained in the product or its emissions. I can just pause here. You will have read from the respondents' experts that they say one of the problems with cigarettes and tobacco products is these poisonous substances, these harmful substances. That's precisely what the legislation is actually directing regulations at. It's to try and minimize that. It's to control and regulate the substances that may or may not be added to the product. The ignition of the propensity of cigarette. The ignition propensity, for example, understand, not being a smoker myself, but I understand that cigarettes have some sort of device in them that actually prevents ignition. So if you're not smoking, it's to prevent a hazard fire, that sort of thing. Product design and composition. So the legislature, we're not short of legislation in South Africa, and regulations are very effective in addressing these issues for health concerns. And if the issue is a health concern, that's to be dealt with under this legislation and those regulations. Not to hijack the DMA and now try and achieve an objective that is said to be, purports to be in the interest of health, and we submit, if anything, is furthest from this. Because when we look at this Tobacco Control Act, what is quite apparent is that there's got to be very careful supervision and regulation and control over cigarettes and tobacco products. We've now been, unfortunately, moved into a world where what is flourishing now is uncontrolled, harmful, probably more addictive because whatever substances are being included, and astronomical pricing. And that, one doesn't need much imagination to understand through history what the effect is of prohibitions of this nature. They've all been a spectacular failure in achieving the objects. The way in which you, with respect, achieve your objects, the health objects, are through measures such as this Act that we have. Now, if I can go to the Disaster Management Act, it actually contemplates, with respect, that seems to have been overlooked by the respondents. If I can start, before we get to section 27, may I start with section 26? The 26 reads, the National Executive is primarily responsible for the coordination and management of national disasters, irrespective of whether a national state of disaster has been declared in terms of section 27. Now, sub 2 is particularly important. The National Executive must deal with a national disaster. I want to move to sub B. In terms of existing legislation, so the starting point must be, in respect of a national disaster, the starting point must be 26. 26(2)B. If there is a declaration, it says in terms of existing legislation and contingency arrangements as augmented by regulations or directions made or issued in terms of 27(2) if a national state of disaster has been declared. So in other words, you start off with the national legislation that is in place. That is what's directed to serving health issues, and as augmented for directions. So you've got to find that there's a need to augment what is already in the Act and the regulations under that Act. These long-term positive consequences that the Minister keeps championing and saying, well, we'll achieve a long-term benefit to society, that is all being addressed by national legislation. What this court has to be satisfied is that there's an immediate need in a disaster management crisis for those regulations under that legislation to be augmented. And we submit with respect, certainly not, and not in a way that that has been achieved.
If you don't mind me looking at that, you're arguing that the tobacco legislation that currently existing should have, not could have, should have looked at to
you're saying is your starting point is there is legislation, and what has to be considered then is there need to augment? Yes.
Now, I'm not sure I saw this case made out in the paper. If I missed it, maybe tell the way.
Lord, it's not made out as a factual case. It's a legal argument that I'm presenting because I'm using it to interpret in Section 27.2 what its place is. We have challenged in the papers whether it's ultra vires 27.2. And your Lordship will have seen that there's a great deal of debate about the meaning of the word necessary. A lot of it we submit is a completely irrelevant debate. Whether it's strictly necessary, reasonably necessary, it actually leads nowhere. Because what one can't ignore, the elephant in the room as it were, is the word necessary. It's still got to be necessary. And interpreting necessary, there's no point in looking, as the respondents do, at a whole host of cases unrelated to what we're dealing with. Interpreting necessary, you look at Section 26 in order to interpret necessary. That's where 26 features again, very important in the interpretive exercise. So for the purpose of 27.2 is subject to subsection 3, and the powers referred to in subsection 2 may be exercised only to the extent, so it's only to the extent that this is necessary for the purpose of, and so forth. You've got A to E. Now, we submit when you interpret the word necessary there, you will take into account all facts. Is it necessary? And necessary with reference to inter alia, the national legislation. So what I'm presenting to the court is legal argument to support this debate that we're having about the proper meaning of the word necessary for the purposes of 27. And we submit whatever threshold you adopt here, whether it's reasonably necessary, strictly necessary, absolutely necessary, doesn't really matter, because you're still going to find this necessary. And what is necessary about it is only one reason given. Is what we say with respect, and we submit we're not overstating it by any stretch of the imagination. We are saying there's one explanation given, it's a speculative one, that the literature does suggest that there may be an increase in the burden through smoking. Well, what literature we've seen, the literature goes all over, and this court obviously can't determine, not even a scientist can determine whether there's an answer. But when we look at the expert, what the respondent relies upon, particularly the WHO, they themselves say it's inconclusive. There's suggestions that it might be, but as Dr. West points out, the expert who's given an affidavit for the applicant, we don't get the material upon which that was based. We asked under Rule 35.12, very importantly, we asked under Rule 35.12 for the documentary support for the study. Because after all, if a minister is going to take this bold step of prohibiting, based on that, because that's all she based it on, if that's what she's going to do, then surely you look at something in the nature of this particular statement from the WHO, which isn't scientific in its terms, but if you look at that, you certainly call for backup material, because you don't need to be a scientist, and certainly not a rocket scientist, to understand. If you want to know what is the increased risk to the burden on the health system, which smokers are we talking about? Are we talking about persons who were admitted to ICU who were smokers but were obese, that suffered diabetes, that had cardio conditions? What are we talking about? What survey was done? What empirical evidence is there to support this? And to make a prohibition as far-reaching as this, on a simple basis that the WHO have said that smoking may be linked to an increased severity in the response to COVID, with respect, they can't pass any threshold. So, getting back to where I was on the interpretation, the question is, first down to 27, then reading it in the way we submit one has to, has it been demonstrated that this was necessary? Now, We've referred the court to an authority dealing with the onus, and we've used it, Moises case, which says that when it's an infringement or limitation of rights in a constitutional context, the onus is on the regulator to justify it. Our learned friends in their responding heads last night say, well, that doesn't relate to this matter because we're not dealing with a constitutional challenge. The principle is the same. If you're going to restrict what is otherwise legal, and you want to outlaw it and criminalize it, then with respect, you must justify it. And the onus must clearly be on the second respondent to justify. So we submit that the onus is foursquarely there. Ultimately, whether the onus is there or not, let's even assume it's neutral, the onus. At least the person who regulates and prohibits is expected to provide some rational basis for this very, very far-reaching, what we submit is a draconian measure. So we submit with respect that as a starting point on legal principle, onus is on the second respondent, and that she has failed dismally to address it. There are a number of very concerning features in her approach in this matter, which I will address as I go through the various arguments on rationality. And even when we get to remedy, what has emerged regrettably is a predetermined, and we've said a steely determination to keep this ban in place. And for what purpose? We keep asking the same question. What purpose? It's to alleviate the strain on the health services. Well, then we've got to find that there's some rational link between this, and we'll deal with that. So going back to section 27, that is the test we submit. It must be necessary. It must be necessary in the sense read with section 26. In other words, that there isn't sufficient to address this problem of the harmful effects of smoking and tobacco products. I may then just also deal with why we say in the first instance that even under the initial regulations, initial lockdown regulations, it was permissible, and why there seems to have been this public debate between the DA and the Minister, particularly of Police, in relation to whether it was permissible. And it was raised by FITA themselves. They also contended for an interpretation, and part of the relief we seek is a declaratory order that it wasn't prohibited, it was permissible. No doubt that's what prompted in the next regulations to remove any doubt, to make it absolutely expressly prohibited in case there be any doubt about it. But if I can just tell the court very briefly, when we look at the initial regulations, chapter 2, which talks about essential goods, the court is by now very well aware, is defined as meaning goods referred to in paragraph A of Annexure B, as amended and so forth. If we look at Annexure B and then A, goods, there are 5 categories. The first category is food. I don't suggest, it probably comes close to it, I don't suggest this is food. Second is cleaning and hygiene products. Third is medical. Fourth is fuel, including coal and gas. And the fifth one, importantly, is basic goods. Basic goods, including airtime and electricity. Now, what is a basic good? And with respect, what answers the question very easily here, everybody has to accept, and the respondents certainly do, is that you're dealing with a legal addictive product. Once people are addicted, and it's not an easy matter simply to switch off summarily the ability to smoke and source supply. That's a completely far-fetched attitude which I'll deal with in rationality. That, we submit, qualifies as a basic good. It's as basic to a consumer of cigarettes and tobacco products as is air, as is food, as is cleaning products. In fact, interestingly, under item 5, basic goods including airtime and electricity. Airtime is regarded as sufficiently important as basic. So, airtime and electricity is included amongst, it says including, but it wasn't exhaustive as to what is basic goods. And we submit on any common sense approach. When we read just one reference, if I may give, in the case line reference 10-93, is in Dr. West's report, but we submit it's not controversial, this. Everybody seems to accept this approach. If I can take the court very briefly to one paragraph at 10-93, paragraph 4, Roman 4 of his report. And this is a critical paragraph when it comes to assessing whether this falls within the basic risks. What he says is tobacco withdrawal is a diagnosable, valid medical condition. What characterizes, again, the second response whole approach is her dismissive attitude. We've got this rather untenable stance that has been proven that within a couple of days you get over the effects of withdrawal, and that smokers will then be rehabilitated and the addiction will have disappeared. If only it were that easy. Unfortunately, there are industries made and built on assisting people to give up this addiction. And in one simple, with respect, sentence of absolute arrogance, she has determined that if you stop people smoking within a couple of days, I'll get over it. So what he says is tobacco withdrawal is a diagnosable, valid medical condition. To leave it untreated and to expect those affected to white knuckle through what could be a very unpleasant period is not in keeping with the best available evidence and treatment guidelines. To treat the condition with self-help books and individual telephonic counselling as advanced by the respondent is unlikely to have any meaningful impact, short-term or long-term, on the successful quit rates of smokers in South Africa or the overall prevalence of smokers in South Africa. Smoking isn't a phenomenon peculiar to South Africa, it's an international phenomenon. It's been around for as long as anyone can remember and before, and this is a very serious addiction. Unfortunately, it's not being treated with the seriousness that it deserves. It is a medical condition. Dr. Scott has also said it's a medical condition, and none of the respondents' experts differ on this. The respondents' experts only focus on why they say that the literature put up by the applicant doesn't really, in all instances, support the applicant's thesis, that there isn't a connection, or that it isn't harmful. The whole watermark of the respondents' experts, really, is to say that tobacco and cigarette smoking is harmful. That's not the debate.
But does it matter that the second respondent says, for tobacco withdrawal problems that may be there are healthcare facilities that are open that people can access to their attention? Does it matter?
Definitely not. In fact, that's part of what we submit is a completely irresponsible response. If one's looking for irrationality, it's difficult to find something more irrational. It's as irrational as a stance that the way you're going to stop illicit traders is you stop people smoking and the price will then reduce and that will drive people out of the market. You just got to say that to see how absurd it is. But if you accept on a clinical basis, on a common cause, uncontroversial basis, that it is a medical condition, that with respect means you can't simply guillotine it and say, well, go to the pharmacy and over the counter you can get nicotine substitutes. That's her solution. Or self-help lines. On no stretch of the imagination can there be a rational approach to this. And why it's important is because when we consider whether or not smoking has indeed stopped or been reduced to the necessary extent, it doesn't matter if it's harmful or not. The question this court has to consider, can it be rationally justified on the basis that smoking will have ceased? But you can't just cease it. You can't simply switch off day one of a lockdown and say you may not get cigarettes anymore. The most remarkable submission in our learner friends responding heads last night in this regard is in paragraph 89.3.2 of their responding heads, page 33. Just to demonstrate how with respect all over the place the respondent is. What the submission is in the head is, they say in 89.3.2, the former is not an incursion at all. They are dealing with the whole constitutional issue, which is really a red herring. The state is neither forcing an individual to smoke, nor forcibly preventing him from doing so. That's exactly contrary to what she says. The object has to stop people smoking, because if she is correct, if she were, in some surreal world, that in fact it stopped people obtaining supplies, and it has caused people to stop, well then how does one defend this proposition? That it hasn't forcibly prevented them from doing so. That's our whole rationale. They say by prohibiting the sale of tobacco, the state commits no invasion into the realm of a person's body. Well, that sounds like textbook stuff, but it's not in the real world. But the one thing that is absolutely remarkable about the whole approach taken by the respondent is her belief, and the argument that's been presented on her behalf, that A, it's only the sale, they say in their heads, that's been prohibited, not the smoking. But then they've got to show the link. They've got to say the prohibition of sale will stop smoking, which they can't. But I'm going back, I've gone slightly out of order, but I want to go back to the original regulations, because I'm submitting to the court that and that's why we have a prayer within our notice of motion declaring that it's not unlawful, and it was lawful, even under the original lockdown. When it first was then purported to be unlawful was only because of the introduction of a positive prohibition in regulations 27 and 25. That's when it became unlawful. And that's no doubt when the Western Cape and others then realized now they've got to deal with an express prohibition in the regulation, rather than the interpretation of the initial regulations, which only left it to interpretation of whether this was a basic good, which we submit quite clearly was. So we submit then one has to test, in the light of the principles of interpretation, what the threshold is then for the purposes of section 27. Has it been shown to be necessary for the purpose of 27.2 and 27.3? We submit on no possible basis has there been any necessity demonstrated. And if we look at a number of factors, and to get back to Her Ladyship Justice Lasson's question to me earlier, ultimately it is a balancing act. You've got to take all considerations, and no one is necessarily determinative. And this is an unenviable task to try and regulate and try and help in the COVID fight. But what we find here is an obsession, firstly with alcohol and cigarettes, and we know that alcohol has now been permitted, which we submit on the evidence, uncontroversial again, is far more harmful to health. And the health services, because we're not concerned with harm to health, we are concerned with increased burden on the health services. The link that has to be established here is between the sale of a product and an increased burden on health services. Now let's take alcohol. It is mentioned in the papers. It increases incidence of violence. It increases motor vehicle accidents. There are effects on one's health, severe effects on one's health, and so forth and so on. We don't need to imagine too much about the disastrous and hazardous effects of alcohol. But yet, well, heaven help us, that is an entirely inappropriate route. We cannot, with respect, trust those who are involved in this process in regard to this matter. This process has unfortunately lost credibility in the rationality of it. And that, with respect, is not the appropriate measure. What we're asking the court to do is, if you grant the relief, that would then mean that there is no longer a prohibition in place. And we stop there. So we don't, it's not a review in that sense, it's not a constitutional 1676 remedy, and so forth and so on. We submit all that is needed is the relief that we seek, and that's the end of this matter. There's no further relief that is required. And in fact, any other relief would simply play into the second respondent's hands to try and further delay this matter. We cannot afford that. With each passing day, there's enormous harm being caused to the economy at large, to people's lives. We see the depression, suicides, and so forth that's been described in the papers by the withdrawals. The poorest of the poor are the ones who are suffering particularly, because they, instead of spending money now on hygiene, sanitizers, and improving their quality of life on food, will be paying black market prices now for these banned substances. That's the world we've been driven into now. And when informal sectors and informal traders and spaza shops keep begging, please relax it, it's destroying our businesses, it's fallen on deaf ears. Why? Only one explanation: because smoking could increase the burden on the health services. But when we read the WHO material, it doesn't say that. Now, I'm not going to burden the court with reading it, the court's read it, but if I could just point out one part of it. And I'll do it briefly. In NDZ 8, I think it's volume, I think it's 8 on case lines at page 193. And let's just look, this is the sort of material that is relied upon by Minister to make this regulation, this prohibition. So we have this general statement that we've been reading for decades, all our lives, about the effects of tobacco. And it's not insignificant, with respect, that South Africa and Botswana are the only countries in the world with this ban. There was a wild statement made by the minister that it was also banned in Israel and India. We did the research, it's not. In the Rule 3512 notice, we asked for the material on which she made that statement. What does she produce in response? She gives a press cutting from the Jerusalem Post, which in the initial lockdown in March, Prime Minister Netanyahu had simply indicated, this is a press report, that there's going to be severe restrictions. The restrictions in Israel were really through vending machines, but the sale of tobacco was not prohibited, and certainly isn't, nor is India. There are 2 countries in the world that have banned it. And again, when we get to rationality, just to think of it logically for one moment, isn't it remarkable that our minister considers that this is necessary, but not one other country that is fighting the scourge considers it necessary or justifiable?
But okay, so doesn't countries take so many decisions in light of the current situation?
Of course, sure. But the question is, there's also a lot of scientific testing. There's statistics coming out of those countries. And there's not a question, I'm not dealing with autonomy of countries. We're talking about rationality in making a decision. And they are relying, the response are relying upon the World Health. The World Health Organization is dealing with an international issue. And we submit the fact that no other country, other than South Africa and Botswana, have banned smoking, does speak volumes. One can't ignore that, because there must be the obvious question. You need a very strong justification if nobody else considers it to be necessary. But this is what the WHO says at page 193. In the second paragraph, tobacco smoking is a known risk for many respiratory infections and increases the severity of respiratory diseases. A review of studies by public health experts, can't get more hearsay and broad and vague than this, convened by WHO on 29 April, found that smokers are more likely to develop severe disease with COVID-19 compared to non-smokers. It's interesting that date, because this publication statement was only 11th of May, after that original prohibition. So obviously this wasn't even available to the Minister when she originally promulgated. But a study found more likely to develop severe diseases. As the experts have pointed out, it's a very vague statement that. Where's the data for this? Who was included in the survey? Who was included in the study? As I indicated earlier, are these amongst people who were admitted to ICU? Is it people who weren't admitted? Is it people who were admitted with comorbidity? There are so many, on a very superficial, basic level, this wouldn't pass any test to satisfy you that there's a need. And then in the fourth paragraph, WHO is constantly evaluating new research, including research that examines the link between tobacco use, nicotine use and COVID-19. WHO urges researchers, scientists and the media to be cautious about amplifying unproven claims that tobacco and nicotine could reduce, because there was a theory here, there still is a theory amongst certain quarters, that in fact it reduces the risk. It's not proven.
Isn't it because COVID-19 is a new disease and the scientific knowledge is still evolving?
Absolutely. Quite
so
right.
you can't expect studies around the potential links between the use of tobacco products and the COVID-19 to have already been undertaken.
Yeah, so there have been studies. There have been studies scientifically in many countries, and it's inconclusive. But your lordship's with respect is absolutely correct. Because of that, then if you don't know, then you don't have a basis to prohibit. Because if you don't know, you can't do it on the basis under the sections 27.2 that's necessary. On what possible basis, informed basis, can you say it's necessary now to impose the prohibition? So it's because, as your ladyship correctly says with respect, it is new, it's novel, it's unknown territory. Quite right. That's one of the large criticisms directed by the applicant's experts at the approach taken. They say you don't know enough. It may in fact be the other way. It may reduce. We don't know. And that is the problem. Where you don't know, to then ignore all the other enormously harmful consequences in a state of not knowing, that is indefensible. And that's why they say there's currently insufficient information to confirm any link between tobacco or nicotine in the prevention or treatment of COVID-19. So what they're warning against is they're saying rumours abound that nicotine or tobacco may reduce the risk. Be careful about that, they said. The evidence isn't yet sufficient to find that.
Can I just interrupt you? But what should we make with the statement in the same document that says, this one paragraph up, available research suggests that smokers are at higher risk of developing severe disease and death. I understand that the paragraph 4 emphasizes more whether or not nicotine can contribute to the prevention, the treatment of COVID-19. But isn't that contrary to what was stated in the previous paragraph? What should we make of that?
Yes. Well, what we make, my lady, firstly of paragraph 3, is that it's really not supported by any empirical data. For a court to find that paragraph 3, the mere say-so, is good enough, can never be sufficient with respect. So, as your Lordship Justice Molefe put to me, this is all very early days in this pandemic.
But that leads to the following question: how far can a court interrogate the integrity of the studies in that infrastructure.
You can't. And that's why we submit the correct approach here is if you can't show that it is, in fact, established, then there's no basis for a prohibition. Until and unless there's proper evidence, there's no basis rationally for that intervention, that prohibition. And then you weigh that up against all the other factors, which we will do. So what is significant perhaps also is that, firstly, this isn't a scientific paper in itself. There's no supporting documents. And when we asked under 3512 for it, the answer was remarkably, I don't have any of it. If you want it, ask the WHO. What does it tell us? It tells us is that this minister did not have at her disposal and did not consider interrogating what is said as a conclusion. And what these scientists, this court can't determine, because not even the scientists yet know. But it's good enough with respect that the court knows that you can't say. And if you can't say yet, then there's no rational basis for the prohibition. Merely to speculate that notionally it could increase, we don't know, may or may not. Getting back to the interpretation of section 27.2 and section 27.3, that can never with respect pass the threshold of necessary. It's necessary to address. Now, unnecessary, we have the benefit, and our learned friends responding heads, they've referred to a judgment of the Constitutional Court in PECO and others, and they equivalent any metropolitan municipality. It's reported 2012, volume 2, South African Law Reports, at 598, Constitutional Court. And that had to do with the Disaster Management Act, and it had to do with evacuation. The Red Ants were authorized by the local council to evict residents from an area that was considered to be under threat by virtue of a sinkhole. And there were dangerous conditions in that area. What this court initially ruled that in fact it was permissible and intra vires the Metropolitan Council to order eviction of people who refused to move, to be evacuated. It was reversed by the Constitutional Court. And the Constitutional Court dealt particularly from paragraph 38 of that judgment with the approach that should be taken. And if I can just very briefly read just a small portion of it. Her Ladyship, Justice Nkavinda, delivering the judgment of the court, says in paragraph 38, properly construed and read in conjunction with other provisions, including section 55.1 and 2.1 of the DMA. Section 55.2D does not authorize eviction or demolition. What it authorized was evacuation. But what had been authorized by the municipality was eviction and demolition of their homes without an order of court. On its wording, the DMA deals with evacuation. The word evacuate is generally used to describe what is done in a situation where people's lives are at risk as a result of impending disaster. Evacuate means to remove from a place of danger to a safer place. The people concerned, therefore, require immediate removal to a safe temporary shelter away from the disaster area in order to preserve their lives. And you'll see from the next paragraph, the Constitutional Court said this is just going too far. This was executive overreach because evacuation is not the same as eviction and certainly not demolition. Section 55.2D authorizes evacuation to temporary shelters for the preservation of life. This means that the DMA ordinarily applies only to temporary removal from a disaster-stricken area to temporary shelter. It implies that those evacuated may return to their homes, if possible. This is not the case here. Evacuation is not the equivalent of eviction, much less of a demolition. On the municipality's own admission, no purpose would have been served by removing the applicants without demolishing their homes, because they would otherwise have returned to Bapfontein. So the argument from the council was, if we don't demolish and ensure that you're evicted, you're simply going to come back. And that's why it was said to be a necessary measure under the DMA. Evidently, this is not what Section 52(5)(2)(d) sanctions. And when one reads on, the court was very clear that you must take a narrow interpretation. Bear with me. I just want to find the paragraph where the Constitutional Court said you must take a narrow interpretation of the DMA. I'll give you the passage in a moment. So the approach taken was very much in line with what we argued. To make a regulation under 27(2) and 3, it must be shown to be necessary. Necessary for that purpose. And the only link here is the most tenuous one, as I've indicated, of based on this WHO, very inconclusive. NDZ9 is similarly inconclusive. All high-level, certainly a science exam would not pass on this answer. And the best it gets, as we see from page 198 in the conclusions from the WHO, is that the available evidence suggests that smoking is associated with increased severity of disease and death in hospitalized COVID suggests. You don't know who, what other conditions, and so forth. Sorry, I was looking, the paragraph is paragraph 42, where the Constitutional Court said the municipalities' powers following upon the declaration of a local state of disaster must be exercised only to the extent that it is strictly necessary for the purposes set out in 55(3). Must be strictly necessary under that Act for that purpose. And what this Court has to find is that there's been evidence to show it is strictly necessary. And we submit that this can't never pass. So we submit you don't even need to resolve this science dilemma, whether it does or doesn't increase the severity in the reaction. Because unless this Court is satisfied that there's merit in the respondent's argument that there is no longer an illicit trade and that there has been success in cutting down smoking and that has been sufficiently quick, the positive effects from that, to reduce the burden on hospitals and health services, unless all of those links can be shown, then it goes nowhere. So let's start with the illicit trade, because fundamental, if you can't find that, if one rejects, as any common sense would dictate that one should, if you reject the contention that illicit trade will be prevented through this ban, it will drive them out of the market. If you reject that, well then you know smoking is going to continue. So people can continue sourcing, and a sufficient number can continue sourcing, and they'll continue smoking therefore. And we know there's a UCT study. There are two studies. There's the study that's relied upon by the respondents, the HSBC study, over a certain period that's been criticized by the applicants' experts and so forth and so on. But on any basis, even those studies, what's quite clear here is you're not given any data to show reliably that there will indeed be a cessation of smoking. What we know is that that study that the respondent relies upon was a very early stage in the lockdown. And as has been observed, that's a completely unreliable test of what is being bought. Firstly, who was interviewed? We've asked for the material, who was interviewed, where's the data? Doesn't exist. So this survey that was even done at the initial stages, March, April, by the HSBC, we submit, as the applicants' experts say, it's a very unreliable exercise. But UCT did a far more extensive one. Clearly, this Court can't resolve necessarily that, but there's got to be something sufficiently reliable to show that there's been a significant or appreciable reduction in smoking that has had the positive effects that the Minister wants to achieve here in the health system. And there's a complete gap here. So the explanation that by banning sale, you are now going to stop smoking, that's a non sequitur.
Wouldn't you agree on principle that there was already a problem with the illicit trade of tobacco products before the COVID-19 pandemic?
Absolutely.
And does the fact that some people will continue to attempt to source tobacco products unlawfully, does that mean that the prohibition of tobacco products, say, is irrational?
My lady, so with respect to conflating two things.
Yeah.
The fact that it was available before and continues to be available, that means that people can still smoke. Unless the minister can achieve a cessation in smoking, she can't achieve what she says is the object here. Because it's not to stop people smoking. She says, I've got to stop people smoking in order to reduce the burden on hospitals. So your ladyship refers to what she refers to, well, there always was illicit trade. That's not the issue, of course. There was and it continues, and it always will continue. We've seen from history. That's not the issue. You've got to find that the source will be cut off now. Because unless you can find that there's no longer a source, then people will continue smoking. And if people continue smoking, then what does the ban achieve? There's nothing left in her rationale, because it's a single ground she's given. She's given one single ground for this regulation, that it will stop smoking. So she's got to bridge that gap. She's got to show that by banning sales, there's no longer going to be a supply from anywhere, and that's going to result in people stopping smoking. Now we submit that is so far-fetched. And it's not the fact that there was always illicit trading, it always will be. That just supports our argument. It supports our argument that you're now going to have supply continuing. It's not going to stop. And as long as that supply continues, there's nothing left of the argument for the respondents. So we submit that as we've seen in our heads, the golden thread here that unravels the entire argument for the respondents is what we submit is an incontrovertible fact, that banning is not going to put an end to the supply. And now we weigh up. So if we know that, and there's what is left of the argument? There's a possibility, no more than that, as suggested by literature, not proven anywhere in the world, that smoking might possibly, in some world that we're not told how, might possibly increase the burden on the health services. Well, you can't change that if people are going to continue smoking, because they can get it. But that's what you told in the one side of the scales. So the one scale, the minister's argument is only one. Let's weigh up now all the other considerations that have to be taken into account. The economy, employment. Huge, 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 huge. We're talking about billions. And then let's weigh up the health. If we're looking at health, and we're so concerned with health, let's consider the adverse health consequences by virtue of the ban. What it's now doing, one saw it with alcohol. People were drinking the most adulterated substances, causing enormous harm. People were dying from it. And with tobacco and cigarettes now, it's exactly what will happen. Because when you can exploit a market, and you're not controlled by the tobacco legislation, and you've got free carte blanche, this is heaven for the illicit trade. They can charge what they want, they can mix it with whatever they want, they can make it more addictive, because then they hook people in. All sorts of narcotic substances can be and are mixed with these substances. And now we're into a completely uncontrolled, unregulated, toxic environment. And we're looking at health hazards and an increase of the burden on the health system. We submit it doesn't require terribly much thought to see where this balance lies. And we've identified in our heads many of the considerations which we say have been ignored. So when we consider the rationality or reasonableness or justification for the ban, what is it going for the justification? Very little, if anything. We submit nothing really. And nothing certainly that outweighs the enormous other consequences that we are suffering on an ongoing basis. So we submit with respect that her explanations and I'll deal with them very briefly. Explanations such as, we've got to put an end to supply. The way to put an end to supply is stop people smoking. Stop people smoking will drive down the prices, and it will no longer be a lucrative market. It's very difficult to give any credence to such an untenable proposition. Any basic common sense would indicate that there's no realistic prospect in the real world, and certainly during the lockdown period, of stopping people smoking. There's no realistic prospect that you're going to stop the supply to people who need it, who are addicted to it. And yet there's a complete disregard for the enormous emotional, psychological, physical impacts that this is having on people. Times are stressful enough under lockdown and the restrictions that we have in a responsible fight against COVID. And people now have to also contend those many millions. We're not talking about a few people here. There was as an extra page, there were 600,000 people who signed a petition in no time opposing the ban. That was disregarded, but apparently first it was said to be 2,000 representations pro the ban, then it became a couple of hundred, and many of those, apart from the duplications that she put into her papers and the record, indiscriminately so, ultimately it transpires when you look at those representations opposing the lifting the ban, many of them were not saying we are resisting or opposed to lifting the ban. Why are you lifting the ban for cigarettes but not alcohol? And that was interpreted as being opposed to lifting the ban. One has to be very careful, but the 600,000 people almost that signed a petition, they ignored. That didn't seem to be of concern. And we submit, when we read the second response answering affidavit and the reasons for decision, scant, if any, regard was given for the countervailing considerations, all these other enormously prejudicial, detrimental considerations. Lord, my ladies, we don't suggest, and nobody with respect could responsibly suggest, that there isn't any validity in the concern about the hazards and effects of smoking. Of course there are. There's hazards from driving. Every day we take our lives in our hands. There's hazards from living, from consuming certain beverages, from eating certain foods. But that's what life is about. It's about a balancing, and it's about a realistic balancing. You do take certain risks because on a balance, it's considered rational and justified. And that's why we've described this as a sledgehammer to beat people into submission, because that's what it is. To force people immediately to go what they call colloquially cold turkey on smoking. It's an act of cruelty. And people are desperate. And this explanation now that it spreads it actually fights the spread of the disease because you're going to stop people sharing cigarettes. You've got to credit people with some intelligence. If anything, when people can't get the substance, there'll be more sharing. It just makes absolutely no logic or common sense. But that's the type of explanation we've got to read. At that level, to say, as Dr. West points out, if you want to look for high risk factors, take a cell phone. Studies have shown thousands of times a day people are lifting it to their faces. That is a cesspool of germs, bacteria and viruses. You don't ban cell phones. Why is it that tobacco keeps getting targeted? It's become an obsession. So we submit with respect that none of the reasons given by the second respondent passes rational muster. And the regulations and the DMA is not there for the minister in her discretion to think it's a good idea. And it might possibly, in her world, be an answer to stop people smoking entirely. There may be an answer to her that if you do that, you're going to reduce the burden on the health services. Well, that's in a make-believe world with respect. That is unachievable. In a real world, to imagine that you're going to stop people smoking through this ban is entirely far-fetched. And if this court were to uphold that, it would be to be supporting the proposition that the ban has that effect. That it has that effect, that it's going to stop smoking and it's going to drive the illicit traders out of the market. While we submit on no possible basis can that be found.
Could I just clarify something based on what you said? Arguing around rationality now.
Correct.
The minister in paragraph 89 of the answer that I made says something about how we as a court should approach the mentioned issue. She says, our approach should be whether there was any literature that should look at, and whether based on that literature, it can reasonably be concluded that smoking presents heightened COVID-19 risks. You have that right?
I've got it, yes.
What is your comment?
So first,
Is she stating the test correctly?
sorry, my lord, I couldn't
Is
hear.
she stating the test correctly?
No, as I was going to submit. Firstly, it's an objective test. The court has to find that there's a sufficient basis shown, factually, scientifically, through proper evidence, that this is necessary, the ban. So the fact that she may have consulted and formed her own opinions about what the literature may or may not be suggesting, that's not good enough. And she's wrong with respect that when she says not the role of the court to weigh up. Of course it's the role of the court. So we submit with respect that her approach is wrong. The test is wrong. She's urging the court to not second guess her, to be completely differential to her as a secondary legislator, and that if she thought that the material does support what she's saying, well, that's good enough. It can never be good enough.
No, not the authorities. The cases, the long line from pharmaceutical budgets
Yes.
say when there's something of an abstract nature, shouldn't the court be fair to the expert rather than impose it on you? Isn't it what she's saying?
No, so what your lordship's talking about, and we quote those cases in our heads, where there's a specialist body, for example, then the court should generally be differential. It's still got to be rational. Even then they'd have to show. They can't just jump to their own conclusions. But this isn't the case. She's not an expert in this field. She's a Minister of Cooperative Governance. This is a sui generis position. We're not dealing here with an expert body. In fact, if anything, what we do know, the advisory committee, and this isn't contradicted, we've said the advisory committee must have advised the President before his announcement, when he announced that the ban was going to be lifted. He must have been advised by, he's got a committee of scientists, he's got of experts. That, with respect, is not challenged. When we say he must have been advised by people in the know and by experts, that's not challenged. The only answer we get to that is when the President said what he did, we shouldn't have understood that as a decision finally. We should have understood that as him saying we're going to continue with our consultative process. Well, that's just false. There was nothing suggestive when we've got the transcript of the President's speech. There was nothing suggestive that it may be lifted. It was going to be lifted, and he no doubt wouldn't have done that unilaterally. He's given no affidavit in these proceedings, and we've said in our papers, and we said in the supplementary affidavit, no doubt when he made that announcement, he must have been acting on advice from the experts. So to answer your lordship, firstly, she's not the expert on this. So it's not a differential matter at all, where the court has to defer. But even if it were, what she's saying in that paragraph is, if it's good enough, if I found some literature in my download from the internet that suggests that it may, that's good enough for rationality. We submit that's the wrong test.
Let me take you back to one other aspect that you highlighted earlier. I didn't want to stand
No, thank you.
as to why you went for that man about Pretoria. She mentions that, and I think you argued that there are about between 8 and 11 million smokers in South Africa. That's what you like. And you said you can't just shut up that number of people and expect them to smoke. That's your argument.
Correct.
She says, of the 8 million smokers in South Africa, I think she said 1%. If 1% of them were to require medical assistance, that would overwhelm the available health care facilities in South Africa.
Yes. So that's purely hypothetical because she's got no basis for saying 1% will require ventilators. As West points out, it's a completely unreliable exercise that. He says, firstly, you're not going to have 1% all in the ICU at the same time. Of the 1% of smokers, or the category she's talking about, how many of them have other conditions? 80% or 85% of people don't require hospitalization. 80% don't, 15% may but don't need ICU. So there's a very small percentage of people ultimately, and as he explains in his affidavit, and no doubt the court will have very careful regard to what he's saying, because it's not a question of a different opinion. He's doing a purely observational exercise. He's showing that in fact it's a completely irrelevant statement that, because you're not going to ever get 1% at the same time in ICU needing ventilators. So on that proposition with respect, it's not established anywhere and it's a totally unreliable statement.
When you say unreliable, because you see, we've got to decide this matter on the fact that can be presented
Sure.
to us. She's mentioning the figure of 8 million.
With no facts.
You say that's hypothetical. She says South Africa has about 3,500 beds today. Right? And 1% of 8 million, that's what she said. She said that's hypothetical. We shouldn't take confidence.
So what I'm saying is there are no facts to support a bold statement that there could be 1% at the same time requiring ventilators. That's what I'm saying.
Just on the fact that the president has been signed it affidavit, we don't have any evidence why he hasn't.
No.
But your clients make much of this point. Are we being invited to speculate?
No, I'll tell you where the relevance lies with respect. So we're quite mindful that not every party has to post an affidavit.
Yes.
See, from that you wouldn't draw an inference.
Yes.
However, there's something else screaming out for an explanation from him. He's the one who made the announcement that it was to be lifted. You would assume that he'd have some rational basis for having made the announcement. In other words, he would have been advised by the experts on this.
Yes.
He wouldn't have simply made an announcement that's going to be lifted without a proper consultation, thought being given, and being advised by the experts on this. Now, that's why we say in those circumstances, an absence of an explanation is important from him. Because her explanation is with respect to non-explanation. She says he mustn't be understood to have been saying categorically. He should have been understood as meaning we're still going to have a consultation process. Well, Faye didn't say that. But it's far more important what we're saying is not said. When we say in our papers expressly that he would not on his own unilaterally have just made that announcement. In fact, he singled it out. When one looks at that announcement, it's the only thing he really focused on at the beginning of that speech, to say that's what's being lifted under the next level. And when we say, because we don't know the inner workings, we've asked for minutes, it's been refused. We've asked for other documents, they've been refused. When we say he's a responsible president who would have made the announcement on an informed, considered basis, that, with respect, cries out for an explanation. For him to then say, for somebody to be able to say from personal knowledge, it was an uninformed statement, or in fact, I didn't have sufficient, or the experts didn't know enough, or they changed their minds. But we don't have, I can speculate from here to eternity. We don't have any of that. So what we say, submit to your Lordship is that the mere absence of an affidavit isn't of any relevance. But it's the absence of dealing with what is calling out for an explanation. That's what's of relevance. And that's the significance of why we make much of the fact that he hasn't deposed an affidavit, because he's the person who should be justifying why he said what. And we don't get an explanation from the second respondent. Well, I see it's just after tea.
Thank you very much. We'll take our break.
Thank you.
All right, court.
The process in the Pretoria High Court where the Fair Trade FITA was applying for a decision by the courts in terms of the government's ban of smoking and the sale of cigarettes during this lockdown period. The Pretoria High Court hearing the Fair Trade independent, all right, Tiny, you'll have to run that for me. The Fair Trade Independent Tobacco Association FITA challenge in court of the banning of smoking and sale of cigarettes and tobacco products to make prohibition as far-reaching as this is just because the WHO said smoking might be linked is not sufficient. That's the argument they sent there. They're saying that if you're going to criminalize, then you must justify it, and that the onus is on the second respondent, and that's Minister Dlamini Zuma saying she's failed dismally to address this argument. Those are the conversations coming out of there. We'll continue to see what the outcome will be. Let's take a break. You're watching The Agenda.
but an industry body one would expect. But it goes without saying, it's a matter of logic.
But here the request for representation was after the president's announcement.
Yes, that's the point. And the point is, at that point in time, and it's a really short space between that announcement and when the regulation was promulgated. So we make 2 points of this. One is, if one look at it a pure Audi approach, and it's just a factor. It doesn't have to be determinative, it's just a factor. Anybody who would have been in favour of the ban being lifted, the people who are addicted to the product, process. The only point, and I'm not trying to overstate it, I want to simply make the point that between the announcement and her announcement, nobody would have thought it necessary, that's all we say, to make representations. Then the way she put it, that we will still consult about it, very equivocal really, as to whether or not the President's announcement is no longer the decision. Doing is, in respect of people who are addicted and in regard to this whole industry, you're criminalizing something. Now, if the need was so great that that drastic measure was necessary, then maybe there's an argument. And that's why ultimately it's a question of valuing, it's a value judgment and weighing things up. And we submit, when you look at the motivation for the ban, it is so weak. The risk of an increased burden on the health system is so tenuous, at best, that then to have as one of the consequences now that people are turned into criminals is with respect to a very undesirable state of affairs. And it does impact upon rationality. And that is what those cases have stressed. And we submit that there needs to be judicial control and oversight over conduct of this nature, where a person takes it upon themselves to make what otherwise is a legal, lawful activity and a medical condition and summarily criminalize it. And we submit with respect that is irrational. The separation of powers, and His Lordship, the Judge President presiding, put to me this question of being differential. We deal with it. We deal with it from paragraph 106 under separation of powers. We're very mindful that there's got to be a separation of powers and we defer to expert bodies. We submit she's not an expert body in that sense, but B, in any event, even an expert body has to act rationally. And we submit that there's nothing that justifies it. The onus I've already addressed, and we submit the onus is squarely on her, at least, even if it were to be an evidentiary burden, she would have borne that onus. So, and we submit with respect it falls. The conclusion then, Lord my ladies, is we referred to the judgment recently in this division of His Lordship Mr. Justice Fabricius, which no doubt you're familiar with. So I don't need to read it. But His Lordship made, with respect, a very, very strong and compelling statement about what the effects are. And this is what, again, in working out rationality and proportionality and whether something's justified, one should also have regard to what the effect is of this type of conduct, which doesn't enjoy the support of the community. When this is a common fight, where you should be in a partnership position, what we find is a particularly secretive process. It's rather worrying when this is the common fight and you're not letting to facts and figures and information. The irresistible inference is there isn't any fact or information that's relevant. That's why it's being withheld. But we are told, essentially, when we asked for minutes of these meetings of this body and the committee, we're told it's top secret, state secret, you're not entitled to it. But the whole process has been a very secretive one. And with respect, that's not appropriate in our type of democracy, and particularly where we are all fighting and we're victims of this crisis. We're in this together. Regrettably, the approach that's been taken is, as His Lordship warned against, that you will turn this into an economic wasteland. If we continue with these sort of punitive, draconian measures without buy-in from the community, without support from people, the right-thinking people who don't see any rationality in something, you're then going to destroy the purpose. You're going to undermine the purpose. And as I indicated earlier, if there's to be any concern for the health services, it is through this new illicit product, blossoming industry. That's what's going to increase the burden. People are now unregulated, not controlled, and as His Lordship says, you're going to lose the credibility, you have a disrespect for the rule of law, and when you're trying to fight a pandemic, as we are, what you need is education and you need people to cooperate. What you don't need, and that's counterproductive, is hammering people with a sledgehammer, beating them into submission and dictating to them what they will or won't do. And we submit with respect what we set out in paragraph 119, the quote from Mpepu's causes case, we submit is particularly opposite to this conduct. And His Lordship concludes in paragraph 9 that we've quoted, thus if government is held to these constitutional obligations and the citizens' trust is restored and lawful rational regulations are obeyed, the expected flood of litigation will retreat and the spread of the virus will be contained until the appropriate vaccine is found. The fact of the matter is thus simply the following: communality or failure. And we submit what we're looking for is communality. This approach, irrational, is doomed to failure. And it's undermining the entire fight that it's so nobly set out to achieve. So we submit with respect that, going back to the amended notice of motion, which in volume, I think it's 6, page 1, the relief that we seek is in prayer 2, 6-2. We've addressed the court on why we submit they are essential goods. And as far as 3 is concerned, if you bear with me a moment. So I'm I'm just waiting for an instruction, if I may ask for one moment. Thank you. Yes. So the cost order that's sought in prayer 3 stands. We submit that the engagement of free counsel was justified. It's been, as the court will have seen, a great deal of work in a very short time, and it was a reasonable precaution to engage free counsel. Our lawyer friends, if I'm not correct, I think they got 4. So we persist in that relief, as the court pleases. Thank you.
Ladies, one fact that we should not forget in deliberations on this matter is that we are dealing with a new pandemic which is ravaging not only this country, but the whole world at a rapid rate. So the responses that those who have the responsibility of looking after the lives, the health and the lives of the country have to take that reality into account. In other words, the responses have to be proactive, and the responses have to be swift. We don't have the luxury of having inquiries that will take time and that will consume resources of the state before action is taken. Action has to be taken on the basis of what is known. Although the body of knowledge is increasing, what science tells us at present and what science tells us is probable has to guide the actions of the state. Lord and ladies, we shall rely in our address mostly on the supplementary heads. For one thing, they are shorter, and secondly, they effectively in our submission deal with the submissions by the applicants. We first deal with the applicable standard of review, and that is to be found in paragraph 3 of the supplementary heads and paragraph 35 to 39 of our fuller heads of argument. And our main submission in this regard is that the minister's decision to promulgate regulations pursuant to Section 27(2) and is executive action and is subject only to legality review. Our learned friends appear now to accept that proposition. Although in their heads and in the affidavits that were filed, there appeared to be a suggestion that the decision might be subject to parja review, but that has been thankfully abandoned. In paragraph 7 of our heads, we reiterate that the minister's decision to promulgate regulations pursuant to Section 27(2) of the Act is executive action for the reasons set out in paragraph 37 to 37(6) of our heads of argument. And FITA's only response to this is a bold assertion that the decision is not polycentric. However, FITA itself also contends that the minister is required to weigh a number of competing considerations. In other words, we submit that it cannot have things both ways. The minister's task involves striking a balance between a number of complicated economic, medical, and social considerations so as to protect the public from the devastating effects of the pandemic. And we submit that by that token, that decision is manifestly polycentric. Now, with regard to the onus, our learned friends quote.
Sorry, are you going to address us on an expansive basis on the rationality
Yes.
of the decision
Yes.
maker?
Yes. The applicants quote the decision of Moise as authority for the proposition that the respondents bear the onus to justify the lawfulness of the regulations because they are a restriction on otherwise lawful activity. We submit that Moise is not authority for that proposition. What in fact Moise says is that once a limitation of a constitutional right has been found to exist, the state bears the burden of justifying that limitation in terms of Section 36 of the Constitution. Therefore, there's no general onus to justify a restriction on otherwise lawful activities. Justification onus arises only if a limitation of an identifiable right in the Bill of Rights is shown to have occurred. And we submit that no such limitation has been established. In fact, in this case, our learned colleagues have upfront indicated that theirs is not a constitutional challenge. Otherwise, obviously, they would have had to file a Rule 16A notice, etc., and indicate what right is alleged to have been infringed.
So what do we have? The restriction on the sale of tobacco products. What is it? Is that a restriction? That's all there is to it, or what is it?
Yes, it's a restriction of the sale of tobacco products for a limited time, in order to achieve certain purposes which are stated.
So you argue that it's not a limitation because that's not the case made out.
That's not the case made out. Yes. In any event, Lord, if one pleads a limitation, and the authorities are quite clear on this, the person must identify the right in the Bill of Rights that is alleged to have been infringed. And there's no such allegation in the papers. That's not the case that is being brought. I know that in other matters, which are before other courts, the right, for instance, mentioned in Section 22 of the Constitution of the Bill of Rights is alleged to have been infringed. In another case, they refer to the rights in Section 12, subsection 2 of the Constitution. But this is not the case here. No such right has been put up as having been infringed. Now, in their heads, dealing with the question of ultra-virus and the empowering position, FITA argues that Section 27.2 does not confer an express power to restrict the sale of tobacco products. The minister has no such power. And we dealt with that in paragraphs 113 and 115 of our main arguments. But FITA makes this submission on the basis of the maximum expressio unius est exclusio alterius. Now we deal with the fact why that is not applicable. We refer to the matter of the case of Zenzile.
Is this in response to the reference to alcohol?
Yes. Yeah. In the Act. In the Act, yes. They say because there's a specific reference to alcohol and there's no reference to cigarettes, therefore there's no authority to restrict or prohibit the sale of tobacco and tobacco products. And we, in paragraph 19, we deal with the reasons why that cannot be the case. In paragraph 21, we submit that the purpose of the general power under section 27(2)(n) is that the legislature could not possibly contemplate every sort of disaster that may occur and attempt to confer specific powers relevant to all disasters. That's why 27, as a mistake there, it should not be 28, it should be 27(2)(n) empowers the making of regulations regarding, and I quote, other steps that may be necessary. We'll come back to the wording here of may be necessary to prevent an escalation of the disaster or to alleviate, contain, and minimize the effects of the disaster. The legislature was not able to predict with absolute certainty what steps may be necessary in a given situation, and so elected to leave this within the discretion of the minister. And we submit that on that score, the interpretation by FITA is unduly narrow and runs contrary to the purposes of the Act. If in fact FITA is correct, we submit that the minister could only ever limit the sale of one class of goods, namely alcohol, regardless of the disaster and regardless of what was necessary in the circumstances. We submit that that's an untenable proposition. We then deal, my lord, my ladies, with the question of necessity. FITA argues that the impugned regulations are not necessary as required by section to which I've referred in section 27.3. This requires, firstly, determining what necessary means, and secondly, assessing whether the regulations meet the required standard. And this we have addressed in our main heads, and I'm not going to repeat. This is from paragraphs 116 to 137 of the main heads. And also at 120 to 131 of our main heads. We submit that the test of absolutely necessary cannot apply where the minister makes regulations to deal with a pandemic situation in terms of section 27.2. Instead, we submit that the regulations must be necessary in a sense that they are reasonably required in order to meet the objectives of section 27.2n and 27.3.
Do you have authority for that? We should understand necessary within the sense of reasonably required.
Lord, we deal with that in the main heads. If we can just go to the main heads at paragraphs from paragraph 116.
The case line page number,
013. It's 013 and page 58. Yes. Where we state the following. That's at 120, the question is what the applicable test is. When will a regulation be considered necessary within the meaning of these provisions? There is, to the best of our knowledge, as yet no reported case concerning the meaning of the phrase may be necessary in 27.2n or the word necessary in section 27.3. Later on, my lord, my ladies, will show that there is a constitutional court decision which interprets a different section of the regulations. We dealt with this in our original heads and in our supplementary heads, and my learned friend has referred to that decision in his argument. We submit that the term necessary has been interpreted in other legislation. It has been held to mean, on the one hand, indispensable or absolutely necessary, or on the other hand, reasonably necessary. Much depends, we submit, on the context. We deal with the case of Congo, in which the Constitutional Court considered the meaning of necessary in section 84.1 of the Constitution. That section 84.1 gives the President the powers necessary to fulfill the functions according to him. The Constitutional Court held that the necessary powers conferred on the President by this section were only those powers reasonably necessary to properly fulfill the functions endowed by section 84.2 of the Constitution. Then we deal with other cases. Ndlovu would deal with the Namibian case, presided over by former Chief Justice Mohammed. This is paragraph 122.4. In the Namibian case of Atchison, the court interpreted the meaning of necessary in a provision of the Criminal Procedure Act, which provided that a court before which criminal proceedings are pending may from time to time during such proceedings, if the court deems it necessary or expedient, adjourn the proceedings. The court held that the word necessary meant reasonably necessary in the circumstances of a particular case. This is obviously to be contrasted with expedient, which it held to mean what is advantageous, proper, or suitable to the case, judicious. And we also refer to the case of Mantiginga interpreting the Ciskei Constitutional Decree of 1990, where the court held that a restriction of a fundamental right applies only insofar as it is strictly necessary for protecting the values enumerated in the restrictions clause. I pause here, my lord and ladies, to mention that in the PECO decision referred to in our heads and by our learned friends, the constitutional right that was being protected in that matter was the rights conferred by Section 26(3) of the Constitution. And as we have submitted, in this case we are not dealing with the protection of any constitutional right. In fact, we do mention that case in the next paragraph, that in PECO the Constitutional Court stated that a municipality's power used a different provision of the Act, 55(2)(d), may be exercised only insofar as it is strictly necessary for the purposes set out in 55(3). That means that the powers concerned may not be used for purposes other than evacuation. As my learned friend has correctly pointed out, the section in 55(2)(d) of the Disaster Management Act dealt with evacuation. And what the municipality did in that case was not to evacuate in that sense, but it was to evict people and demolish their houses. That was obviously yes. The section in the Act relied upon was the evacuation to temporary shelters of all or part of the population from the disaster-stricken or threatened area if such action is necessary for the preservation of life. That is the section that was being interpreted in PECO. And what the municipality did in that case was not to evacuate the people, but actually to evict them and demolish their structures. So obviously, in that case, the action of the municipality were unlawful. Well, we submit that the courts did not, in fact, squarely consider or deal with the meaning of the word necessary. And we submit it was not actually necessary to deal with it. Or as we say, it was not strictly necessary to deal with it. And to that extent, we say that that expression, strictly necessary, might actually be regarded as obiter in that case. The statement is made in answering the question whether the municipality's powers was exercised for the authorized purpose, not whether the exercise of that power was necessary. And we continue dealing with that. Now back to our supplementary heads at 02011. Court will bear with me. Our attention is being drawn to what follows in our original heads, 01362, paragraph 124, where we say we submit that necessary in sections 27.2n and 27.3 means reasonably necessary rather than absolute necessity or indispensability. And we say so for a number of reasons. The first one, that a proper interpretation of the legislation gives effect to the purpose of the Act and broader legislative context, and prefers a sensible meaning over one that leads to insensible or unbusinesslike results or undermines